And we're live. There will be no intro today for a number of reasons, but not because of all you rude folks who claim that my intro is too long, because I have the shortest intro on YouTube. It's only like 2 minutes long. Get a life. Hi, everyone. Welcome back to another installment of Empowered Esquire TV, more recently known as the Empowered Esquire podcast. So I'm sure you see the title of this video. So I am sure you are rearing to go and ready to discuss the recent goings on in the criminal prosecution of Michael Nowak, I believe is how you say the last name, also known as quote unquote Brother Polight. Let me say what's up to a few folks. Hi, Kimberly Callahan. Yeah, it's been a minute. It's been a minute. I'm not on here as much post pandemic. The pandemic was just, it slowed us all down, right? And I found that I had so much time, and this was a great way to use that time. I don't have as much time now, so we're making it work. Hi, Salt. Yes, I still do vids. I'm not sure why you're not getting notifications, so you should look into that. Hello, Black Anonymous. Everybody, Black Anonymous has a channel where he gives commentary. Check him out. Hello, Tripsy's Treehouse. Check her out as well. She also does a lot of commentary and has done quite a bit of commentary on this case. Same with Negus Rosell. Check him out as well. Hi, Black Girl Magic. Hi. Hi, Texas Bama. Hi, Issa. How are you, Issa? All right. Hello, Seven Steel. And one of my faves, Mara Charisse. How are you, darling? How's everybody doing? All righty. So we are not going to delay. Here's what we're going to do. I have not watched his sentencing at all. You are getting my true and honest and really raw reaction, right? So we're going to head over to Queen Throne's page. Did I say, is it Queen Throne or Queen's Throne? Queen's Throne, right? We're going to head over to her page. She's awesome. She always has the actual hearing taken from the recording, if you will, or the live version of the hearing, and then she puts it on YouTube, right? So if you ever want to know what happened at a hearing, I recommend her page because she has all of the hearings on her page. All right, so we're going to head over there. We're going to watch the hearing. I will stop it intermittently, give my commentary, and then we will dig into some law and some questions. Some of you already posted some questions on my community wall, but you'll have the opportunity to call in as well, okay? First Lady A says she wasn't getting notifications either. I don't know what to tell y'all. You guys know that the conspiracy theorists say that YouTube has a conspiracy against content creators of a certain, how do I say this? Group. Okay, we're gonna leave it at that. So I would say check your notifications. All right. And if you are here and for some reason you're not subscribed, I don't know why that would be, right? Because you know you love it here. All right. What's up, Claymore Jones? And hello to TSW OCOV. What's up to the whole OCOV fam? Diva as well. I'm glad y'all are here. And hello, Neo X. All right. So here we go. I'm going to share my screen and we are going to dive into Queen's Throne. Well, really not Queen's Throne, but really the hearing. But thanks to Queen's Throne for having the hearing available for us to watch, right? Okay. I'm going to share my screen. I don't know why I always announce that I'm sharing my screen. For those of you who aren't new here, you know that I announce it. Why? I don't know. Okay, you should be seeing it. Let's make sure. You are perfect. All right. Let's get started. Now, let me say this before we start digging into this hearing. Queen's Throne has posted the hearing for us to be able to watch. All credit to her on posting it. Thank you so much to her for posting it, right? And here is the link to her original video. All right.
Mr. Michael Nowak on page 20.
Okay,
and then we have the trial where the jurors are outside, I presume.
Yes, or well,
No, where are they? Okay, all right. As long as they're gathering up. All right, let's go to page 20. Michael Nowak. This is on for plea.
LB Marcus on behalf of the state, and just for the record, Your Honor, there are a victim's family on the Zoom. If we can make sure
Okay.
that's
Your Honor, Mr. Novak is heading up the escalator now. There has been a very last-minute change, material change to the plea offered by the state just this morning, so I haven't any time to relay this to him because it could be a deal breaker.
Okay, well, just to let you know,
So I want to stop it right there because there's some things I want to make sure we're taking note of. What was just said on the record is that there was a material change, meaning a quote unquote important change made to the plea by the people, aka the government, the morning of. So we know that eventually we're going to hear something in this plea that was not there before. That's the first thing. And that second, defense is already preempting that they really have not had a time, if you will, to consider this because it just happened this morning. Now, the reason that both of those things could be relevant in the future is because A, we may hear something that was added for the purpose of giving the quote unquote victim, which now would be the survivor, right? And the family some sort of solace, right? And we may also be hearing defense try to state that they weren't given sufficient time to review this plea. Now, in this instance, we know that he ended up taking the plea, right, according to the internet, because again, I haven't even seen this yet. But that is something that may come up again in the future. Okay.
I'm supposed to be starting a jury trial in 5 minutes.
Judge, I know that we can come back tomorrow.
yeah, the victims are present. They've taken off of work and off of school.
They're present on Zoom?
On the Zoom. They are with a lot of coordination to have this done today.
All right. Is this your client here? No?
No, I believe he's an observer on this case who has presented threats to us in the past, so I would want to make the court aware of that. It was an issue the last time the settlement.
Okay.
Make an inquiry of him while he's here.
Yes, sir. What is your name, sir? Yes. Okay, Mr. Jones, apparently counsel is saying that there have been threats made to him, and if there haven't, we're in a clean slate right now, but if I hear of anything from this moment on to anyone, you're going to have to answer to the court. Everybody is entitled to their opinion, but when we're in a court of law, when we're dealing with matters, there should be decorum and respect. So I just hope that everybody appreciates that. That's all I'm going to say. I'm not accusing you of anything, sir. All right? Okay. So you need to speak to him. You've got a new, is this going to be a written plea agreement?
There's a written plea agreement. There is one line that has changed. However, as the defense mentioned, it does change the terms in terms of what was listed. That they need to review and with the clients this morning.
All right.
Is one line.
All right, we'll pass it. Again, if it takes too much more time and I have my jury ready to go, I'm bringing them in. That's going to be my priority.
Understood.
Okay, thank you. Okay, no, all I can tell you is an allegation was made. Everybody's presumed innocent in this court, sir. All I wanted to do is let you be aware that they've made the allegation. It's a clean slate. Everything is good. Okay. All right. Alvin, are all the jurors here?
Yes.
All right. What are we doing with Mr. Nowak?
They're
Outside?
knocking outside. Let me go
Okay.
through there.
Yeah, I've got to get this. Folks, we got to either take this plea now or I've got to start the jury trial. What are we doing? All right. Quickly. All right. Let's try this again. All right.
We want to be clear, however, that the individuals who we're concerned about are not going to be able to hear, only that the victim and her mother are going to be able to hear.
So pausing again for us to make note of some things. So remember it was stated that something was changed, right? Okay, so now it's been stated on the record that quote unquote brother Polight, Michael Nowak, and his attorney took a moment to speak, which I imagine was them deciding whether or not he would still take this plea with the change that has occurred. Now, the government characterized it as one line. his defense attorney characterized it as a material change. So let's keep going.
I do not know how to do that at this juncture. You had brought this to my attention.
Was brought to your officials in between the last hearing and this hearing.
Well, it is unfeasible right now.
I'd ask if the state assistant state attorney can make an attempt to call them and have them here by phone. Because if your Honor is going to be speaking and there's all of these individuals who are going to be here able to, they're not going to be able to talk, but they're able to live stream, and that's not what we're intending.
Folks, you're raising issues that the court was not aware of. I have a jury sitting outside waiting to come in. If you wish to reset this matter, this courtroom is always open. Zoom is a convenience. But as of right now, we do have those who are attending. I'm not going to just delete everybody from the proceedings. I honestly don't even know how to do it and just leave somebody able to hear everything.
It's being streamed right now live on YouTube.
Okay, well, if it's being streamed, it's being streamed. There's nothing I can do about that. Whoever wishes to attend.
Your Honor, I believe that it is.
So I have to say, this judge he's a judge. If you're picking up what I'm putting down, right? His courtroom is open. There's a reason he's saying that. Throughout this case, there have been complaints about people attending when they're from YouTube. People put it on the YouTube. Oh, cry, 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 right? But as the judge just said, the courtroom is open. So unless it was decided at the beginning of this case that this is to be held in a courtroom that is closed, meaning not open to the public, then the courtroom is open, right? And by the way, public access to the courts is one of your constitutional rights. Did you know that? Yeah. Okay. So this idea that you don't have the right to attend these hearings or these proceedings is completely false, unless it was decided that the case was to proceed in a closed courtroom, and that was not decided. All right.
Open courtroom, but the Zoom is not required.
I understand that, but I don't know how to go ahead and take out everybody except for one individual. They're already here. You're bringing this to my attention now. I'm giving the opportunity. If you want to reset this for tomorrow, we can do that.
Your Honor,
I have a jury trial that is sitting outside the door.
the concession the state made regarding crossing out that last line, the last term, was with the understanding that this would happen today because of the victim being out of school, the people being out of work. If this gets reset, we're not willing to amend that term.
Can we have, Your Honor,
I want to make sure you don't miss anything. The line that the government allegedly changed in the plea deal that defense counsel was complaining about and already trying to adjourn the plea to another date. Now it sounds like they took that line out to get him to go ahead and plea that day. Okay.
victim and her mother be put into the breakout room with the court so that only they are allowed to hear the proceedings?
Quite frankly, I can put someone in a breakout room, but then they're now prevented from hearing what goes on in this courtroom. We're not in a breakout room. You're putting me in a very difficult position.
Courtrooms are open, and that's the nature of
Then
courtrooms.
we're going to go forward. 4-page plea agreement that was signed by the counsel. It was signed on today's date. And on page 1, there is a line on paragraph 5. I cannot read what the handwriting says, so maybe somebody can assist.
Your Honor, the state has crossed out one line of paragraph 5 and has written on the side, this crossed out line does not apply, and then initialed and
Crossed out
dated.
line does not apply. Okay, and that's your initials there?
Correct, Judge.
Okay.
Your Honor, before you proceed with the plea, we do have an amended information that we're filing right now.
Okay.
The state, in case F21-14438, is filing an amended information for purposes of the plea, and in contemplation of result.
All right, so remember, I'm going to stop and teach. I know that what people usually do here on YouTube is just rah, rah, rah commentary. But if you're new here, I teach. All right. So if that's not your speed, then maybe I'm just not your speed. Okay. So amended information, amended information. What the government means when they say we have an amended information to file is they have amended the charging document. That means that they have changed the original charges to reflect what he is now going to plead guilty to. Now, there are times when that has to happen in order for the case to be resolved, right? So there are instances in which, let's say, for example, a defendant is charged with a slew of felonies and then 2 or 3 misdemeanors, right? And then ultimately, all of the parties decide that, oh, the defendant is going to plead guilty to one of the misdemeanors. Well, to dispose of the rest of the higher charges, in those instances, the people would say, oh, we're going to amend the charging document, right? Amend the information to reflect lower charges, which is a way of disposing of or resolving of the higher ones that existed before. Because otherwise, there may be question of, well, what happened to the higher charges, right? So to get rid of all the confusion, they're amending the original charging document to reflect what the plea is about to be.
Resolving the case of 2 counts of child abuse, aggravated, great bodily harm, or torture, felonies in the first degree, 1 count of contributing to delinquency of a dependent or dependency of a child, a misdemeanor in the first degree.
Please arraign on the new information.
Enter plea of guilty.
I actually have to run that back because that went a little quick for me, and I think I missed it mentally. Let's go back.
21-14438 is filing an amended information for purposes of the plea and in contemplation of resolving the case of 2 counts of child abuse, aggravated, great bodily harm, or torture, felonies in the first degree, 1 count of contributing to delinquency of a dependent or dependency of a child, a misdemeanor in the first degree.
Please arraign on the new information.
Enter plea of guilty.
Do y'all realize what just happened? Now, the last time that we spoke about this case, I said to you all, I find it to be very, very intriguing that quote unquote brother Polight is going to plead guilty to a case with SO charges as the top charges. I said I find that to be very, very intriguing because he was so adamant about his innocence, and SO charges come with the SO registry and all of this other craziness that goes along with it as well. And now we have an amended information that does not have SO on it. Child abuse is not SO. SO and child abuse are not the same thing. So, akin to what my thought process was when we last spoke, he's pleading guilty because SO is off the table. He's not going to have to be branded as an SO. Child abuse and SO is not the same thing. Contributing to the delinquency of a minor and SO is not the same thing. All right.
No, on the new, well, the arraign on the new information. You're entering a not guilty plea at this point. Okay, and setting up the jury trial, all discovery to be provided. And are we ready to proceed?
Yes, sir.
Okay, I can have the defendant sworn.
Raise your right hand, sir. Please swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Okay, I'll need the old information.
I have to pause this because there are adults in the chat that I have to tell them, although I'm sure they are adults, to be respectful to each other. You've been warned. If you are not an adult, you shouldn't be in this chat, okay? And all the adults in the chat, be respectful to each other. What does that mean? Oh, sure. Let me tell you. Do not call each other names. Do not curse at each other. Do not be disrespectful, mean, threatening, bullying, harassing, or nasty to each other in any way. You have been warned. I see it again, and I don't time out. I block. And my block is forever. So get yourself together. Collect yourself.
I want the defendant to be aware of what he was originally facing and what the new information. This is the new information. Okay, can you tell me your full name and date of birth?
Michael Eugene Note Jr., August 10th, 1983.
All right, thank you. You were originally charged under case number F21-14438 with the following charges: lewd and lascivious molestation on a child, a second-degree felony, punishable by up to 15 years state prison. Count 2 was lewd and lascivious molestation on a child, 12 to 16 years, a second-degree felony, punishable by up to 15 years state prison. Lewd and lascivious conduct on a child under 16 by a defendant 18 or over, a second-degree felony, punishable by up to 15 years state prison. Count 4, lewd and lascivious exhibition on a child under 16 years, defendant over 18, a second-degree felony, punishable by up to 15 years state prison. And contributing to the dependency of a child, a first-degree misdemeanor, punishable by up to 1 year in jail. And then count 6 is interference with custody, a third-degree felony, punishable by up to 5 years state prison. The state has now filed an amended information today, charging you with.
Now we're taking another moment for me to point out and for you to notice something. Notice that the charges that he is now going to plead guilty to were not on the original charging document. So remember, we talked about instances in which the charging document has to be changed to resolve certain charges. And a lot of times when you reach complicated plea deals such as this one, right? And you know it's complicated because, again, it entails charges that were not even on the original charging document, right? The people have to amend the information to reflect the plea deal because these charges were not even originally what he was charged with. Remember when we first discussed this case, he was charged with a slew of SA-related crimes. There wasn't just child abuse on there, this kind of umbrella. That was not on there. The child abuse offense was not on there. It was all SO and then just contributing to the delinquency of a minor. So now the information or charging document is being changed to reflect what I assume is going to be a bunch of just C abuse, which I already messed up by saying the whole word anyway. So let's continue.
With the following: aggravated child abuse, great bodily harm, a first-degree felony, punishable by up to 30 years state prison. Count 2 is aggravated child abuse, great bodily harm, a first-degree felony, punishable by up to 30 years state prison. And contributing to the delinquency.
And I just need to make sure we're all clear. So he is pleading guilty to child abuse, great bodily harm. Again, he's not pleading guilty to any SA crime. He's pleading guilty to child abuse, great bodily harm, and then it sounds like he's also pleading guilty to contributing to the delinquency of a minor.
Delinquency, dependency of a child, a first-degree misdemeanor, punishable by up to 1 year in jail. It is my understanding that you wish to plead guilty to this new information. You would be adjudicated guilty, and your sentence has been memorialized in a 4-page plea agreement. Did you have the opportunity to go over this plea agreement with your lawyer?
Yes.
Okay. I do need the defendant to initial each page because there are not initials on these pages. All right. Let me know when it's done. You have gone over this plea agreement with your lawyer, and I want to go over it with you, not each and every aspect of it, but the major components of the plea agreement. But what I am going to ask is for the state to tell me the general terms of the plea agreement, and then we will go into the details on the contract. Go ahead.
Your Honor, the plea agreement includes an adjudication, 7 years of state prison followed by 10 years of reporting probation as a condition of probation.
Now, I want to note that 7 years of imprisonment is a stark decrease from what he was facing before. Okay, let's take a little walk down memory lane and remember that he was facing much longer in prison under the original charging document. Okay, and even quite frankly under this charging document, because remember hearing the judge explain the max penalty of imprisonment for each charge, right? Technically, even under this charging doc, he could have faced much more time, right? So remember, as I told you, plea negotiation and plea deals are exactly that. They are a compromise, they are a negotiation. So when everybody came online and they were doing their prison math and they were like, Polight going to jail forever and blah, 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 I was like, well, we'll see about that, right? Because this whole process is a negotiation. You negotiate, there's compromise, there's give and take. So even on this charging document, he's not getting the most time he could possibly get with those charges, right? This is a negotiation. So stark decrease in what he was facing before to now 7 years. I mean, that is a stark decrease. This is why I always tell you all at the outset of these cases, don't come online and do your little prison math and make your own predictions and then say it like it's law. Bad idea, because I bet you could not have predicted that 7 years is what would amount from this.
The defendant
It's,
will,
what you say, 10 years
10
probation.
years reporting probation. The defendant will complete the MDSO program. The defendant will not be allowed to have unsupervised contact with children. The defendant will
So let's talk about this MDSO program for a second, because someone asked me a question about this on the community tab, and I thought it was interesting. So as we've noted, these charges in this amended information are not SO charges. So for him to be required, by the way, the MDSO program, I don't want to spell it out because, YouTube, but it's a program in the state of Florida. It was kind of started as a way to see if they could address some of the mental illness that tends to surround SO crimes, right? It's this idea that just taking an S offender and just putting him or her in prison does not rehabilitate them. And so you still release an S offender into society, and that puts people at harm, right? So it's a program. It is, to my knowledge, usually like an actual inpatient program, right? It's a program that a person has to live in the program or live at the facility for the program. And they are treated for mental illness that is allegedly undergirding or causing the S offender behavior. So again, very interesting that that's a part of this plea when he's not pleading guilty to any SO crimes. Again, that was probably part of the negotiation, right? And I imagine, quite frankly, that might be part of what convinced the family to be comfortable with this plea. Because otherwise, I can see a family being pretty peeved that you don't have him pleading guilty to any SO crimes. You also hear on the record that he is required to, restrict contact with children. Again, he's not pleading guilty to any SO crimes, but it looks like they are putting on SO conditions, right? And that may be the compromise that was made between the government and the defense. That, okay, we'll keep our SO conditions, but he doesn't have to plead guilty to an actual SO. And again, let's have another teaching moment, right? Plea deals come with conditions. It's not just I plead guilty to, penal code SS0153 and we're finished. Every plea deal has conditions, meaning things that the defendant has to do to hold up his end of the deal, right? That is what we are listening to right now. And again, these conditions are SO conditions, which is interesting, being that he's not pleading guilty to a SO. However, I imagine that was part of the compromise, because like I told y'all in the beginning, it was very, 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 very interesting in my mind to hear him being so vehement about his innocence and then agree to be labeled a SO. So more than likely, the compromise is he is not pleading guilty to anything that would label him an SO, but the government still gets to put in manually all of the SO conditions that they think will protect society from him offending again. Let's continue.
Complete the MDSO program, the defendant will not be allowed to have unsupervised contact with children.
The defendant will complete the MDSO program. The defendant will not be allowed to have unsupervised contact with children.
The defendant will have specific terms regarding where he may work and the ability to wear a uniform.
The defendant will have specific terms regarding where he may work and the ability to wear a uniform.
The defendant will have specific terms regarding where he may work and the ability to wear a uniform.
There are additional terms of restitution, of which $5,000 has been agreed to be paid upfront within 24 hours, mailed to the to the victim.
There are additional.
So let's have another teaching moment, shall we? Did you all know that there are crimes that actually have restitution attached to them? So restitution is a concept that we usually see in civil court, right? So for example, you deprive someone of the use of their property, you pay them restitution. You steal something from someone that causes them loss of income, you pay restitution, right? Things like that. It is usually a concept that exists in, as I said, civil courts, and it's meant to compensate the other person for whatever it is they lost in some way, right? Does money always fully compensate? Of course not, but that's the idea, right? So it's something that you usually see in civil court, but there are certain crimes that come along with the ability for the government to impose restitution. And I'll have you know something that gets even more curious. In the state of Florida, all child abuse offenses, so all of these offenses that are labeled child abuse, and then underneath that umbrella, they all have the potential for restitution. And I think the policy there, and I say I think because this is just my legal opinion, right? I think the policy is if someone harms a child, they have deprived that child of something that the child should be compensated for. Hence the idea that restitution is being applied here. All right. Let me check the chat because I have a feeling you guys are acting a fool again. Let's see. Let me double check. Tobiah Ben Yashar. Ooh, I'm gonna butcher that name. Yasharala. This is the second time that I've seen you causing a problem in the chat. This is the second time. I'm being super nice right now. Okay. All right, let me see, because I think there's some people in the chat that I need to say hello to. Hi to a Jade Stone. Texas Barrett, did I say hi to you? I don't know. I miss you. Terry the Republic. You've been, I think Terry creates content, y'all, so check Terry out. Kimberly Callahan, did I say hi? If I didn't, hello. Penny Crispas or Chispas? Penny Chispas. Hello to Zion Lex. Y'all, Zion Lex has a channel as well. A bit high. Y'all know that's my favorite YouTube name. What's up, a bit high? How are you? All right. Hello to Octavius Juan Kenobi Prime. I like that name. Dope name. Hey, Nakia. How you been? Long time no see. How are you, Nakia? I hope you're well. What's up, the artist formerly known as Nappy Yankee, now known as Naps TV, is in the building. Check him out too, y'all. Oh my goodness, the Umarian meme. Where do you guys get these names from? I missed your hello. My deepest apologies, the Seven Steel story. How are you? All right, let's continue.
Terms of restitution, of which $5,000 has been agreed to be paid upfront within 24 hours, mailed to the to the victim.
There are additional terms of restitution, of which $5,000 has been agreed to be paid upfront within 24 hours, mailed to the to the victim.
And additional restitution to be paid out on a monthly basis once he is out of custody. And that monthly amount is highlighted in the written terms of the plea agreement. Additionally, there will be a stay away order from victim TS and her mother.
Okay, so for those of you who may not be familiar, a stay away order is sometimes referred to as a restraining order. That's usually the term used in civil court, right? And it's also sometimes referred to as an order of protection. That is the term usually used in criminal court. Okay, so it just means, y'all know I'm always dealing with baby Mac. Oh, at least he's not barking, right? This is a step up. So in general, such orders typically just mean the defendant has to stay away from this person. Usually they entail that the defendant also has to stay away from the person's residence. Oh, well, duh, Felicia. The person's place of work. There you go. Their place of business, their religious gathering, right? If they have a specific church or temple or mosque that they go to, right? Anywhere that is somewhere that they are known to frequent, right? The defendant will be ordered to stay away from that place, as well as just staying away from the person in general. You'll hear that the victim's initials were used and not her name. And as I'm sure you know, that is because she is a minor. Okay, let's continue. Oh, wait a minute. I see Mara Cherise and TSW and a bunch of people talking about the like button. And quite frankly, you guys know I'm not a I'm not a big YouTuber. So I'm not very good at monitoring these things. So let me actually check out. Okay. Let me go on the live and see what we got going on here on my phone. Okay. So what I'm seeing on my little phone here is that we have over 100 people in the building, right? And we have 65 likes. Now, in general, do I care about these things? No. But when we talk about these cases in particular, I ask everyone to hit the like button. I ask everyone to share the video so that the information can be disseminated. Because as I stated, there's a lot of rah-rah commentary that surrounds these cases and not a lot of straight talk and teaching. So please help the information get out there. Hit the like button, share the video, okay? Hello to Gelly with the Hanafuda earrings. Hello to Eliarza Yasharala. What's up? Shalom. Ask your question later, okay, Eliezer, because I'm coming back around to questions. Hey, Chanel. Hey, Mo Light and Love. Hey, Inner Peace. All right, so let's continue.
Which is also mentioned in the plea agreement.
Additionally, there will be a stay away order from victim TS and her mother, which is also mentioned in the plea agreement.
Additionally, there will be a stay away order from victim TS and her mother, which is also mentioned in the plea agreement.
What is the total amount of the restitution?
The total amount of restitution is $25,000.
Okay. All right. Yes, Your Honor. Okay. All right. Okay, so Mr. Nowak, the terms of the plea agreement are as what the prosecutor just stated, that you are going to be entering a plea of guilty to the 2 counts of aggravated child abuse and 1 count of deliberate contributing to the delinquency of a minor. You will be adjudicated guilty, which is a criminal conviction on your record. Do you also understand, sir, that by entering into this plea that it may subject you to involuntary civil commitment proceedings set forth in Florida statutes 394.910 through 394.931? Do you understand everything that I've said thus far?
Yeah.
Okay. Now, I want to also advise you, sir, that you are going to be sentenced to 7 years in state prison to be followed by 10 years of reporting probation.
Now, I want to also advise you, sir, that you are going to be sentenced to 7 years in state prison to be followed by 10 years of reporting probation.
Now, I want to also advise.
Now, let's make sure we all heard that. 7 years imprisonment to be followed by 10 years of probation. Now, some of you all think that because a person is out on probation, they're living the life. No. Okay. Let me kind of give you a bit of insight on probation. It requires check-in. Okay, depending on the probation officer, it could have the implication of weekly random pop-ups at wherever it is the person is supposed to be living or wherever it is the person is supposed to be working. Random drug testing, random testing for all sorts of other things, if you will, right? It could involve social media monitoring. Okay, many of these probation officers now are learning that tech is something that's a part of monitoring their offenders, right? So it could entail social media being monitored. It could entail him either being told to stay off of socials or being regulated in what he posts on his socials, right? It could entail him being told where he is and is not permitted to go. It could entail travel restrictions. Do y'all remember how much quote unquote brother Polight loved to travel and show off all his alleged travels? Yeah, all of that could be restricted for 10 years. Okay, for 10 years. And Trip C mentions a polygraph. Some of these probation programs have a yearly polygraph. That is true. I don't know if they're going to mention if this one does or not, so we'll see.
You, sir, that you are going to be sentenced to 7 years in state prison to be followed by 10 years of reporting probation. In addition to any of these special conditions of probation, you will also participate in and successfully complete a mentally disordered sex offender treatment program.
In addition to any of these special conditions of probation, you will also participate in and successfully complete a mentally disordered sex offender treatment program.
In addition to any of these special conditions of probation, you will also participate in and successfully complete a mentally disordered sex offender treatment program. That you are also not eligible. Okay, you may, according to the state, you may be eligible for early termination if all of the conditions of your probation have been completed, that you have had no violations of your probation, and that you have not been arrested for any other.
To clarify, the terms stated in 5 is there is no prohibition on early termination. However, there is a requirement that any modification to this agreement be agreed by the state and the court.
Okay. All right, sir. Now, with respect to this plea agreement, I have on each page next to defendant's initials MN. Did you in fact affix those initials to each page?
I did.
And have you reviewed each and every component of this plea agreement going through page 1 and through page 4?
I have.
Now it says on page 4, having read the above mentioned terms of this plea agreement and having been advised by my counsel, David Terrace, I, Michael Noak, freely and voluntarily enter into this plea agreement and agree to abide by all terms and conditions of this plea agreement and agree that failure to comply with any terms or conditions within this agreement constitutes a violation of probation and subjects me to be sentenced to the statutory maximum penalties provided by law for the crimes for which I am now pleading guilty. And then it has a signature over the name Michael Noak. Is that in fact your signature, sir?
Yes, sir.
All right. And I am now going to place my signature on this plea agreement in that I am now going to be ratifying this plea agreement as negotiated between the state of Florida and your attorney. Has anybody, including your lawyer, told you anything differently than what I've just told you?
No.
Are you under the influence of any alcohol, drugs, or medication affecting your ability to understand me?
No.
Is anybody forcing, threatening, or coercing you to enter into this plea?
No.
Do you understand that if you're not a United States citizen, the entry of this plea will have negative immigration consequences, including deportation and removal?
Understand.
You had the right, sir, to have gone to a jury trial where your lawyer had the ability to compel the attendance of witnesses on your behalf, the ability to confront and cross-examine the witnesses and evidence against you. You had the right to testify just like any other witness or remain silent, and your silence could not have been used against you if you went to a jury trial. You also had the right to appeal any mistakes that I would have made during the course of the trial, and the right to hold the state of Florida to the burden of proving these charges beyond a reasonable doubt. Do you understand, sir, that by entering into this plea, that you are giving up all of these rights and we will not have a jury trial?
I do.
Have you discussed this plea with your lawyer?
Yes,
Has he answered all of your questions?
absolutely.
Are you satisfied with your lawyer's services and advice?
Definitely.
Did the state provide all the discovery in your possession to the defense?
Yes,
Did the defense review all of the discovery in your possession with your client?
Yes, Your Honor.
And do both sides know of any physical evidence containing DNA that would exonerate the defendant?
There you go.
And do both sides stipulate to a factual basis for this plea?
yes,
Thanks, everybody.
And the court has reviewed the arrest affidavit, makes a finding that there is a factual basis for the plea. Mr. Noack, are there any witnesses or is there any evidence that you wanted your lawyer to investigate or me to receive before entering into this plea?
No.
All right. The court
Again, as I said earlier, this judge is a judge. So everything that you just heard is to preempt Michael Noack's ability to appeal this plea and claim that something happened that nullifies the validity of the the validity of his consent to enter this plea. Right? That is what you're hearing happening right now. And quite frankly, as a law nerd, it's eloquent, it's beautiful, it's elegant. Chef's kiss, right? Okay, so he can't claim that he was drunk or high and didn't understand what was happening. That's the first thing. He cannot claim that he was promised anything other than what is in the four corners of the plea agreement. He cannot claim that he did not understand or did not read the entire plea agreement. He cannot claim that there was evidence or issues that he wanted someone to address or consider before he entered this plea. What this judge just did is lock this plea up tight. Okay, so if he ever wanted, and by he, I mean, quote unquote, brother Polight, to challenge this plea agreement, he'd have a hill to climb.
finds that the defendant understands the nature of the charges against him and the consequences of this plea, that he has been represented by competent and effective assistance of counsel with whom he says he is satisfied. I find the defendant has knowingly, voluntarily, and intelligently waived his rights. All statutory fines, court costs, and surcharges will be assessed. Counsel, do you waive PSI?
Yes, Your Honor. Waive PSI.
Now, Mr. Noack, you do understand, as I mentioned to you before, that the state, as they had articulated earlier, you may be eligible for early termination as long as certain conditions are met. That means no violations. You've done everything that you were supposed to do. You've not been arrested for any criminal offense.
So here the judge is saying that he may be eligible for early termination, meaning he may be eligible for having his sentence not be, right, the entire extent of what we've heard. If, of course, he's not rearrested, he's not, and again, probation is included in the sentence, okay? Do not think 7 years as the sentence. It's not part and parcel, it's on the whole, okay? So the 7 years incarceration and the 10 years probation. So here the judge is explaining you may be eligible for early termination, meaning you may be eligible for having that time reduced if you are not rearrested, if you do not violate any of the conditions that we've discussed.
And the state is in agreement with it as well as the court's ratification. On the other hand, sir, if you violate any terms and conditions of this probation, and that includes getting arrested for any other criminal offense, that you could be subject to the maximum period of time in prison, which by my calculations is 61 years state prison. You do understand that?
Yeah.
On the other hand, sir, if you violate any terms and conditions of this probation, and that includes getting arrested for any other criminal offense, that you could be subject to the maximum period of time in prison, which by my calculations is 61 years state prison.
Yes, for those of you who need me to spell it out a little bit more, the judge is referring to the terms of the probation. Yes. But my point was, when you think of this sentence, do not just think of the 7 years of incarceration, because there's 10 years of probation after that. And that is not freedom. It is not freedom. It is not the rights and freedoms that an average citizen enjoys.
You do understand that?
Yeah. On the other hand, sir, if you violate any terms and conditions of this probation, and that includes getting arrested for any other criminal offense, that you could be subject to the maximum period of time in prison, which by my calculations is 61 years state prison. You do understand that?
Yeah.
And knowing all of this, do you still wish to enter into this plea?
Yes.
All right.
And knowing all of this, do you still wish to enter into this plea?
Yes.
All right.
And knowing all of this, do you still wish to enter into this plea?
Yes.
All right.
The court finds the defendant, as I mentioned before, understands the nature of the charges against him and the consequences of this plea, that he has been represented by competent and effective assistance of counsel with whom he says he is satisfied. I find the defendant is knowingly, voluntarily, and intelligently waived his rights. All statutory fines, court costs, and surcharges will be assessed. Is there anything further as it relates to Mr. Noak? I do have on the Zoom that the victim's mother wanted to address the court.
Correct. And Your Honor, nothing more from the state except to let Your Honor know if you can unmute the victim's mother, and she will be listed as victim Noak in the Zoom, and she is requesting, pursuant to Marcy's law, that her identity remain anonymous. So for that reason, she will not be stating her name, but she will be making a statement regarding this.
Where would it
It
be?
should say victim and then in parentheses Noak. Nope, sorry.
All right, you may unmute, ma'am.
Good morning, Your Honor.
Good morning. All right, so what I'd like you to do is, well, you don't want to give your name. So at this point, just go ahead and you can give us an impact statement. Yes, ma'am.
Michael Nowak. This is the first time I have spoken publicly about what you've done to my daughter and I. I have gracefully remained silent the last 2.5 years. 2.5 years of pain, shock, disbelief, PTSD, constant nightmares, and daily triggers. Trying to help my daughter heal when I'm not even healed myself. What you have done to my daughter, myself, and my entire family is inexcusable. You hurt us all. You made me believe that you were such a great.
So Queen's Throne has graciously put up information about what the purpose of an impact statement is. And as we listen to this, I have some things that I want to say and some things that I feel is important to say now, right? Now, as you know, at the beginning of all of these cases, I'm very adamant about not jumping the gun. I'm very adamant about trying to be neutral and respectful, okay? We've reached a different place now, okay? Michael Noak, aka Brother Polight, pled guilty himself. It's not even as though there was a trial and a jury found him guilty and he's saying he pled guilty to child abuse himself. Okay? So now let me take another moment. Kwongja 7, you're cool. I've seen you here before. Who cares? Noak, Noke, Nope, Shok, we don't care. We don't care to finagle over the pronunciation of his name. Now, moving forward. At this point, we can say this. If you are an adult and you do something inappropriate to a child, it is not the child's fault. It is your fault. Why? Because you are the adult. That is both personal opinion and that's also legal opinion because that's how the law views it. Okay? So all of this finagling that people did in the beginning, about her mother, and did the mother let her go with him, and how blah, how well does the mother know him, and blah blah. None of that even matters. He is an adult and she was a child. That's the bottom line. I want to also say to anyone who has been and I like to say survivor as opposed to victim, right? So we're going to shift that language. Anyone who has survived this type of offense, know that what happened to you was not your fault. Know that. And I hope that the survivor in this case and her mother know that as well. He's an adult. She was a child. The idea that any of this could in any way be her fault or her mother's fault is absurd. Bottom line. Okay. So now, victim impact statements. We usually hear these at sentencings. Yes. Very often, the judge will consider the victim impact statement in the sentence imposed. We have a situation that's a bit different here because there was a plea agreement that was agreed to by defense and the prosecution, right? But we still hear the victim's mother being given the opportunity to make this impact statement. After this, I will open up the stream for phone calls. You guys can call in and we could take a look at some law if you guys have legal questions.
Great man, and you could do no wrong. You made me fully trust you, and for that, my daughter trusted you too. But the truth is, you're a monster, a demon. The very first time that I allowed you to be alone with my daughter, the very first time, and you couldn't even help yourself. You told me you was gonna be right back. You were going downstairs. We were gonna grab food and take vacation pictures. You told me that you wanted to have a one-on-one talk with her about loving and respecting me as a great mother that I was and am. And I actually believed you. I believed that you were gonna bring her right back. I thought you were gonna have this trusting conversation with her that you promised me. Her and I both trusted you. For a grown man to violate a child who trusted him, you should be ashamed of yourself. You plotted on me and my little girl. The entire time you knew what you planned to do. Isolate, intoxicate, then violate my baby. Shame on you. I trusted you to bring her right back.
What is going on in this chat? What's going on in this chat? How many times today have I had to talk to the adults in this chat? I'm not playing with y'all. A real one knows what's going on in this chat. I haven't made not a single comment today that was directed at you. And if you're that offended, you should leave. Okay. Be respectful. A woman is reading a victim impact statement. Sit down. As a matter of fact, you've now been banned and blocked. I don't have time. I'm sorry. I was nice to the other one twice, and he's used up all the grace we have available. Bye-bye.
Yeah. You were supposed to bring her back the same way that you took her. Instead, you drugged her and took advantage of her. And you sexually abused her. You forced alcohol down her throat. You then forced her to see things that no child should ever have to see. You forced her to feel things that no child should have to feel. You forced her to accept violence that no child should ever have to endure. You forced drugs in her that no human should ever even ingest. She's my child. My baby. How could you? How could you? You could have killed her with all the drugs that were found in her system. And you thought your master plan was mapped out perfectly, huh? You thought I'd be dumb enough to believe you over my child. And you thought that money would blind me. You thought I was gonna be so blinded that I wouldn't notice when you returned her with bruises all over her body and her mouth busted, uncontrollably shaking. Absolutely not. And although you executed your plan and you got what you wanted those couple of hours, You actually failed. Because look where you're at right now. You have created a lifetime of trauma for my daughter and I. Before you, we never knew evil existed. You brought so much evil into our lives that early morning. And I'll never forget. I called you like 50 times and you wouldn't answer me. And I called her too, but you took her phone. You drugged my baby and you gave her no way to seek help. You left me no way to contact.
So do you all remember in the beginning of this whole case, people said that the mom let her daughter go to a party. The mom let her daughter go to a club. Is that what we just heard on the record in this courtroom? I don't think so. I think what we heard was that allegedly they were going downstairs, like in the lobby of the same building that everyone was already in, to go and take pictures and eat food. That is what the mother gave her permission for. Not all the foolishness that we were hearing a couple of years ago. I keep warning y'all about coming onto this internet and just saying whatever you think you heard that you may want to say. Because truthfully, this woman could sue a bunch of YouTubers for defamation. Let's continue.
Contact her or even know where she was. I get physically sick now whenever I'm away from my daughter because of you. Something as simple as her going to school, I'm in panic mode. Because I'm scared when she comes back, she's going to be hurt all over again. I constantly have flashbacks of that night. And what she lives with is not okay. She feels uncomfortable around people and will live with this forever, and this is not fair to her. She never deserved this. Shame on you for forcing evil on our youth. And you know, for a year, I questioned, how could you even do this to us? Her and I did nothing wrong to you. We trusted you. I moved across the country because I believed everything that you told me. But it was pure manipulation I see now. All you do is specialize in selling false dreams. How could you do this to an innocent child and mother who simply trusted you? We did nothing wrong. But you know what? I'm done breaking my head trying to question or figure out how you could do such a thing. It's so simple to me now. You're just a sick man. A man you can have a plethora of women, but you secretly prefer to have a child.
Oh my goodness. Did you hear what she just said? He can have a plethora of women, but he secretly prefers to have a child. Now, I want to mention something here that I think is an interesting comment, or intriguing is my usual word, right? I'm going to mention something that I find to be intriguing. Michael Nowak, whatever, also known as quote unquote Brother Polight, he's always been polygamous, right? And he's always, well, at least online, he's always professed to be polygamous. And he's always stated that he has multiple wives. Now, I would think that you should be busy, right? With multiple wives, you would think that any man with multiple wives should be busy, right? And so it opens that intriguing conversation about the mind, the mindset, and the true intent behind some, not all, but some of the men that participate in polygamy. It's an intriguing thought, because is it truly a love for all of these different women? Or is it just this insatiable kind of nature that has something else lurking there? Again, not all, maybe some. It's an intriguing thought.
And it's so clear now. I will never, be able to fully trust another person due to the betrayal that you've shown me. And for that, I was not willing to trust 6 strangers and go to trial. Nor was I going to put my daughter through an additional trauma. This plea was in our best interest. You and I both know the evidence is extremely substantial. But even with that, I refuse to have my child be tormented when she's done nothing wrong. All she holds is the truth. And I will say this, although you were so worried about being labeled a sex offender, you did us a huge favor by admitting to guilt, period. So for that, I thank you. I truly thank you. Yes, mitigation took place and I allowed it as long as it meant you going to prison and you getting true help. Because true help means no more victims. The fact that your only non-negotiable was to accept a sex crime shows exactly the type.
So there's an interesting conversation going on in the chat right now. Eliezer and quite a few other people, Eliezer and Shanoa, have mentioned something interesting. So it seems as though Brother Polight, quote unquote, Brother Polight, allegedly has a track record of dating women who have teenage daughters. That's interesting. I mean, because, you know, that's very, very interesting. For those of you who are unfamiliar, there's a story lurking about on the web. You know, I don't really do stories much. I do cases. But there's a story lurking about on the web, if you ever want to look into it, about Michael Noak and a wife that he used to have and her daughter, and some allegations that her daughter left home to be with Polight, even though the mother was no longer with Polight. Yeah. If you ever want to go down the rabbit hole one day.
The man that you are. You know what you did in that hotel room. I know what you did, and my daughter knows what you did. DNA doesn't lie. There's no reason why your DNA should have been found on my baby. And yes, I satisfied your bogus request to not be labeled a sex offender, but it doesn't take away from who you truly are. I wasn't going to waste any time going back and forth with you over a label. God will judge you for exactly the person he knows you to be, a sexual predator. So rest assured, jail time equals jail time.
This is a powerful impact statement. Kudos to the victim's mother, the survivor's mother. This is a very, very powerful impact statement. And, you know, she's made a valid point in stating that the label is for her purposes moot, right? Because for her purposes, she wants Michael Noak to serve time in prison for what happened to her daughter. And she wants him to have to receive some sort of treatment that could possibly prevent someone else from getting hurt in the future. And as we heard, he has the 7 years of incarceration. He has the 10 years of probation on the back end. He has to do the program for mentally disturbed or mental illness that's associated with SO. He has to do that program. He has to stay away from children. Right. So he has all the conditions. As I said earlier, he has all the SO conditions, even though he doesn't have the SO label. So she makes a very, very powerful statement in saying that what is the label to her? She's garnered justice. So listen, if you want to listen to the rest of her statement, I would say go to Queen's Throne. I'm going to link her video again and watch her original video, right? For our purposes, we're going to stop it here, right? And I am going to put the link to the stream in the chat and invite you all to come backstage and ask me any questions you have, right? And let me hop in the chat. You can put your questions in the chat as well. Okay, I'm going to leave Queen's Throne up there for a second for those of you who want to take note of her video. Okay. I think I missed some hellos because I think people, Sis Zakia, how are you, darling? It's been a while. I hope you are well. Blessings to you. Blessings to Mixtress Monica as well. Been a while as well. Blessings to April Showers. Hi, Zin Humara. How are you? Let's see if there's anybody else. World Traveler. All right. How are you? Civil commitment. That must have been during the terms and conditions. I think we missed that. But they probably were referring to the inpatient program. Okay. All righty. So Trip C is in the building. So I'm going to bring her on stage. Let's do this. All right.
Hey,
Hey,
Felicia, darling.
you are on the live. How are you?
Fine. How you doing tonight?
I am wonderful. I'm glad to be here, glad to be well. Not glad to have to discuss this kind of case, but hey, you know,
Right.
at least we got a guilty plea.
Yes.
Yeah.
So,
what do you
my first question is is part of that plea deal where it says I forget exactly what, but then we went to the statutes, and in that part it says that him or any third party harassing or try to intimidate the witness of the victim or the victim's family. So I guess I'm asking this for, I got one part and then there's two actually. One is Sai has been putting up videos with the mother's first name in it. Would that be a violation? And then two, what was the other one? Yeah, the videos that he's putting out. Have you seen those?
So I haven't seen these videos that he's, as a matter of fact, maybe I need to look them up because
I can get you a summary because they just as sick.
Yeah, give me a summary of these videos first, and then I'll give you my opinion. By the way,
the first one
and Neo, and I'll bring you up next. Go ahead, Trip.
The first one was about 9 minutes and some change long, and he was talking about things that they never accused him of, like penetration. I don't even know what words we can say on YouTube no more. This just getting confusing. But he was alleging the stuff that didn't actually happen because remember all the DNA was found on her upper half. And then he was like they were lying about it. He said there were 5 different types of DNA and they didn't find anything in the rape kit. And then the second video that showed up day before yesterday, it was some weird, just disjointed thing about the sperm racing to get the ovum. So you were special because you were the one that was chosen or whatnot. And then the last one, well, no, they put up one today from him calling from the jail. For those of y'all that said he was not incarcerated. That's what he said, mixtures, 5 different types of DNA, baby. I said that's not right. But yeah, would any of these be a violation of those as they're stated? So put out as you heard them?
Yeah. So as I'm sure you all heard, his restriction is that he has to stay away from the victim and her mother and you know their relatives of sort, right? And so in the past, I have heard of defendants going online to discuss victims that they've been told to stay away from, right? And what has happened in those instances is that can be interpreted as you harassing the victim. So are you contacting the victim? No, right? Because technically he's not contacting the victim. However, a judge could interpret this behavior as harassing the victim. And I'm certain that his attorney would advise him not to do what he's doing right now, right? To make videos.
The thing is,
go ahead.
All of these look pre-recorded, like the information that he's putting out on the 9-minute video matches the first 2 charges that he got when he first got arrested. Those are the 2 that have life sentences on them. You can tell by the words that he's using in this little rant that it's old because it matches everything that he was saying back in 2021, right after he first got arrested and let out for them 3 days that he got credited for. I just still find that kind of funny. But you can tell that this was premeditated, and then he got Amunet or somebody loading them on whatever schedule. So it's like he's a so-called social media influencer, and it's been known and it's been proven in the courts already that, you know, people will go to do their bidding without them asking them to, because this is cult type behavior. So, but that's a different story. The thing is can they can interpret this as him intimidating the witness still.
So the legal term would not be intimidating the witness because she's no longer a witness, right? This prosecution has it's been resolved. But as I said, the term would be harassment. This could be interpreted as him harassing the victim. So I'm almost certain that his attorney would advise him not to do this. And if prosecution catches wind of this, they could very well appeal to the court and say, we think he's in violation of the terms. He may not be directly contacting her, but he is harassing her. And
I believe the judge was contacted this morning, bright and early.
Okay.
But it don't do no harm to call him again.
So, this, it's possible that he could be violated if he's found to be harassing her. So, yes, definitely not recommended.
And then coupled with that, Sinetta putting out these videos with the mother's first name in them. You need to listen to this Linda. After you say your heart go out to her, but you putting her name in the title for no.
Put out a video with her name in it when she didn't put her
with
name
her first name. Look, she enacted Marcy's law down there in Florida, meaning her identity has to be protected because her child's identity has to be protected. But it's a whole list of stuff. Now he done sat up there and put her name out on 2 videos that I know of. I don't watch it, but somebody tagged me and was like, "Yo, you need to go look at that." But he done did it twice at the least. So that's what I'm saying with that, and then people posting stuff on his social media platforms because his Facebook is gone.
What has happened? I have to say, and this is a Felicia moment because y'all know I have moments where I have a personality. And I've joked with y'all before that, listen, if you don't like my personality, this ain't the place for you. So this is a personality moment. Do y'all remember back in like 2015, 2016, when Sinetta and the House of Consciousness were like dope, like they were decent people? Do you remember when they used to make videos that had like interesting concepts and gave you something to think about, and it was thought-provoking, and they encouraged community unity? Do y'all remember that? Because what is happening and what has happened? What has happened to him and his platform? For lack of a better question, are drugs involved? I don't know. I'm just questioning because the change in behavior is insane.
And then there's one more thing. I said a little bit on my channel, but I haven't really addressed it. I spoke to the other victim's father. I got confirmation that this happened. I got a little mini rundown of what went on. So yeah, he did that. According to the child's father.
Well, I'm not going to comment on that yet, but let me answer this question, and then I'm gonna unmute Kim and Neo and let some other people have their say as well.
I need to drop down because I've been over here. I gotta go mob for somebody. But thanks for letting me up, and I'll see y'all later.
Yes. Thanks for coming. Go ahead. So West Africa's question: there is a person that implied, as a result of Polight not pleading the blank charges, he can appeal the blank counseling. No, and here's why. Remember, we said that there are terms and conditions that come along with a plea agreement. They put on the record that that program is a part of this plea agreement. It's a part of the terms and conditions. So did he plead guilty to a SO? No, but he agreed to have that program be a part of the conditions. He has to complete that. All right. All right. Welcome, Kim. Since you were first to join, you are first up. What's on your mind?
Can I be heard?
You. I forgot to unmute you. Go ahead.
Oh, goodness. Okay. Can I be heard now?
Yes, we can hear you now.
Okay, great. Now, the question that I have is kind of piggybacking on what the previous person said. In my observation of this online conscious community, you can tell, or I can tell, that people seem to be in league with one another, for lack of a better term. They're associated with each other in some way. And I have seen the association between Sinetta and Polight. And if it is true that Sinetta either A, knew of Polight's tendencies, or B, is making videos naming the mother of the victim and giving out information, I wonder how legally liable Sonetta is making himself by doing that.
Well,
If
that
at all.
depends on the information because the first name doesn't make him liable, right? It's just bad. It's so there's a line, and I'm sure this line exists in all professions, right? But for the legal profession, there's a line between professionalism and ethics. So there are some things that, it's is it illegal? No, right? So it's not necessarily going to impose anything that would put a person in prison or in jail but the ethics of it, right? The professionalism of it says, "Oh, I shouldn't do that." So technically, Sonetta is not in any legal hot water for using her first name. And that is because at the very beginning of the whole case, her first name was already put out there, right? Now, is it ethical? No. And that is my opinion. It is my opinion that it crosses a line of ethics, of professionalism. Quite frankly, we got a question of manhood, maybe even, right? Because men should protect. It crosses
Yes.
a line to use her
Yes.
name. But is there a legal implication there? No.
Can I ask a follow-up question, please?
Yes.
Okay. The follow-up question I have is, if there is information out there about the mother, and there are people who are in this cult-like uh, trance, if you will, of Polight, and I'm just envisioning someone trying to do harm to this woman or her daughter because they believe what Polight says, even though it's not true, and on and on and on. And we've seen that in, for example, the January 6th situation. At what point, I guess, what is the question I'm trying to ask? At if this happens, at what point is either Polight or Sonetta or any other platform that would allow this kind of talk and riling up to go on?
Well, they could be responsible if they are directly instructing people to bring harm, right?
Mhm.
And let's first of all say, because I believe in being mindful of what we put out there. Let's first of all say we are not putting that out there, right?
No, we're not.
Nothing is going to
Absolutely
happen
not.
to her or her daughter, right?
Right.
But they would only be legally liable or legally implicated if they directed or instructed their followers. So, for example, if Senator came online and said, "Everybody who's hearing me right now, I want you to go do blank," right? Then he's implicated. But if people who just so happen to have watched one of his videos choose to do something, he's not responsible for that.
Okay. There's a really thin line I can see,
Yes.
between who would be responsible, and if someone should say something that will get somebody riled up and might, make them want to actually physically do something to somebody. You have to be so careful about being on these platforms and what you're saying.
Mm-hmm. Mm-hmm. Mm-hmm.
So I would hope that parties would take heed.
Yes. Yes. Well, thank you, Kim. You can
Thank
stay
you.
on, but I want to give Neo the opportunity to speak, and then we'll go to Miss Vicky, and then we'll go to Texas Bama. So, hello, Neo X. What's on your mind?
Hey, peace. Thank you for letting me up. I'm gonna be brief. So, when this case first started grabbing attention, when Tasha K reported it, and it started circling amongst the conscious community, right? A lot of people are saying now that they were afraid to speak out because they don't want to get sued or say anything that's going to cause them to get sued. And I just want to know, as you having, experience with the law, can someone sue you if you make a statement saying that you believe a person is guilty versus you saying they are guilty? Can you still be sued if you use the word "I believe"?
So there are nuances there, right? But as I've said in my own practice, I would always recommend the most protective posture, meaning the place where you are safest. You are safest in not referencing whether or not the person is guilty or not until the case is adjudicated, right? So until the case is resolved. Now, if someone says, "I think," that such and such is guilty, or I think they are protected in a way because that is their opinion, right? They're not presenting their opinion as fact. The trouble really comes when opinion is presented as fact. That is when the legal trouble comes. However, I would advise that you just don't do it at all. And that is why in the beginning of the case, I advise people not to predict what they think would happen, outside of just discussing the law as I do, right? And not to say that they think he's guilty or not guilty, not to calculate jail time and all of these things that people were doing in the beginning. I said, I do not recommend that because it's just not the safest place to be. I recommend the most protective posture.
Okay, cool. Thank you.
You're welcome. All right, Miss Vicky, what's on your mind?
Hi, thank you for having me. I had a quick question. Because he's required by the courts to take the SO class, or not class, but program, can we call him an SO?
No. He's not been labeled a SO, and he does not have to enlist in the SOR, the registry. So no, you cannot say that he's a SO.
Okay, so although they are requiring him, it's not like we request that you take this, or it'd be nice that you take this class. They are requiring him. So we just can call him a child abuser, but not an SO.
You could technically say that, but again, I would not recommend. I would recommend that you say he has been, or he pled guilty to child abuse. When you start turning the charge into like a name that you're calling the person, I just wouldn't recommend that. It gets too messy, right?
Okay, so he was charged with he pled guilty
to child abuse, right?
Child abuse, and was forced by the court to take an SO class.
Right. And
I'm looking at 5 years from now when he comes back with that story about the charges being dropped. About, this is his words, basically the charges, the SO charges being dropped. And, that's not what he is. But we can always say, well, the court forced you to take this class, though.
I mean, right. So yes, he can say that he is not a SO. That is true. He is not a SO. And as I said, he's not required to register. But as we heard, he is required to participate in the mental illness program for SOs. He's required to stay away from children. So, yes, in whatever 5 to 7 years or 7 years, whenever he is released, it can be said, okay, he is not a SO. That's true. But he did have to go through some of the same terms and conditions with his plea that SOs do. And also it can be inquired as to whether or not the program actually rehabilitated any of his issues.
Okay, so he wasn't convicted of SO, but forced to take an SO class. Okay.
But he was forced to do the SO program that's supposed to address the mental illness that's associated with those types of offenses.
Okay, that's all I had. I'm looking forward down the line when he gets out, how to combat what he's going to come out and say. Thank you.
You're welcome. You're welcome to stay if you like, or
no, I'm good. I'm good.
Okay.
Thank you.
You're welcome. Texas Bama, you are on. What's on your mind?
Hello. Thank you so much for taking our questions. I think you already answered a couple of them. Let me see. So being that the survivors received some type of restitution in the plea deal, would they still be able to sue him civilly?
So that is a great question, Texas Bama. Yes, they can. So there is still the potential, because this is a criminal conviction, but they still have some other potential causes of action that they could try to seek out in civil court. But I will say this: restitution is usually something that results from civil court. Remember, civil court is about compensation, right? So if they were to sue him, they would be asking for some sort of monetary compensation, but they've already gotten restitution in this criminal case. So his counsel in any civil case could make the argument of, well, you're trying to double dip here, right? You've been given financial restitution in the criminal case. Do you still have injury for which you can seek damages here? Now, that would depend on the quality of the attorney they choose, right? They would have to find causes of action that are nuanced enough and different enough from the criminal case that they could claim that they still have damages there that require compensation, because there was restitution in the criminal case. You got that? Oh, she's still with us, Texas Bama? Oh, I think we lost her.
Can you hear me?
We can hear you now. Did you hear me?
Okay, cool. I did.
Okay. And
yes, I had another question.
Okay, go ahead.
Okay, so in the state of Florida, are you aware, can they really force the child to take the stand?
I wouldn't say they can force the child to take the stand, right? And
Right.
I don't think any prosecuting agency would force a child who really expresses that they cannot handle it to take the stand, right?
Right.
Could the prosecution ask the family to allow the child to take the stand? Sure. But I can't envision any situation in which the child would be, quote unquote, forced if the family and the child outright expressed, listen, we do not want, the child to have to take the stand. Because at the end of the day, the court is interested as well in the welfare of the child. Children have a heightened sense of not only privacy and protection in the court, but also a heightened sense of concern about their well-being. So I can't envision now, legally, could they? It's complicated when there are minors. We know for adults, they can subpoena you and they can force you, right? We know that. But with children, there are so many other things involved. I can envision that a prosecuting agency could serve a subpoena for a child, right? So technically, that would force the child. But then I could see that the guardians or the parents could appeal to the court and say the child isn't, mentally, psychologically, emotionally capable. And I can see a court being sympathetic to that. Long answer, but does that answer your question? We can't hear you.
Okay, what about now?
Yes, now.
Okay, I guess it's because I'm going back and forth from this list that I created, my list of questions. So I did have a couple
Right.
of more.
Did that answer your question?
It sure did. Yeah, you're great.
Oh, wonderful. Okay, move on to your next question.
Okay, thank you. Let's see. So the MDSO program, do you know if it's an inpatient or an outpatient program?
So the MDSO program, from everything, mind you, I have never been involved directly with a defendant that has been given that program, but from everything that I've read and seen, it is inpatient.
All right. Yeah, that sounds good. Okay. And another question I had was the lewd and lascivious charges that he was facing initially. If you could just tell me if I'm right or wrong, but my understanding was that it had to do, like lewd and lascivious has to do with consent or non-consent.
I can't remember off the top of my head, so I'm going to refer you to, I have a playlist on my channel. Go to the very first video I ever did in this case, because I broke down the charging document. I bring up each law, and we even define lewd and lascivious and all of that. I don't have that at the forefront of my mind at this time. Any other questions?
Yes, one more. I just wanted to know, I was so curious to know, what is a breakout room?
Oh, okay. So Zoom has this ability where you can put certain people in a separate room. So what was happening on the record is they were saying, well, can we make a breakout room and then only have people in certain rooms be able to hear what's happening on the record? And the judge was like, first of all, I don't know how to do that. And second of all, no. Because in essence, it would mean that certain people wouldn't be able to hear what is happening in the main room, which is where the live stream is happening. They'd be off in like a separate room where they couldn't hear anything.
Yeah, he pushed for that so hard.
Yeah, because he
Okay.
didn't want anyone to hear, that he has all these SO conditions, because the conditions with his plea agreement are just like an SO. The only
Yeah.
thing is that he's not being called an SO because he did not plead guilty to an SO and he doesn't have to register. But when you hear you have to stay away from children, huh? Same conditions.
Mm-hmm.
Same conditions.
Now, would it be more proper to say that he agreed to take the treatment rather than he's being forced to take the treatment?
Oh, absolutely, because
Mm-hmm.
a plea agreement
Mm-hmm.
is an agreement. So,
Mm-hmm.
absolutely. He agreed to take that program, yes.
Okay, and then just one last question to set the record straight. You did say that based on the plea agreement, he does have to do the full 7 years imprisonment. He won't be eligible for early release of that, but he may be eligible for early release of his probation, correct? If he follows all of the terms?
Right. So the judge noted that he could possibly have early termination of his probation. Now, in the state of Florida, there are certain crimes that there's no early release of incarceration. So, not the probation part, right? But the actual 7 years of incarceration, there are certain crimes in the state of Florida where you don't get good time, meaning there's no release for good behavior,
Good.
there's no time
Mm-hmm.
served, right? Now,
Yep.
is child abuse listed in that? I believe so, right? I'm saying don't quote
Okay.
me on that because I'd have to verify that, right? But the judge
Okay.
explained it very, very well on the record. And
He
the
did.
judge explained that the early termination applies to probation. And to my knowledge, child abuse could be one of those crimes that is listed in the state of Florida's list of crimes where you have to serve it day for day, is what they call it. There's no early release of any sorts.
Okay, well, thank you so much.
You're welcome. All right, Neo X, you had another question?
Yes, and good questions, Texas. I was like, okay. But, okay, so I do have a question. One of my supporters said she's gonna send me some paperwork about the case. Like, I guess she was gonna, what is called when they when they ask for the records, like the charges, the
The
statements,
transcript?
and all. That's the word, transcripts.
Yes. Will you
If
email them to me?
Yeah, well, one of my great supporters is actually going to go get them for me, so I don't have to pay for them. She said she'll do it for me. But my question is, do you know if the what is called the disposition, is that when they take the statements from the defense and the prosecutor of what was actually said, like what was
Yes.
Polite side of the story and what was the victim side of the story? Can we be able to read that?
Yes. So the disposition is legally just what has happened to the case. What is the resolution? So disposition would be defendant pled guilty and here are the charges, right? And it depends on how they list it in their docket. They may just say disposition and then plea, or disposition and then list the highest charge that he pled guilty to. But the term disposition just refers to how the case was resolved. That's all that term means.
Okay, so what is it where they, how they usually sit down and they have the victim give their side of the story, like what was the complaint, like the defense has a chance to question them and talk to them, like
Oh, so you
what
mean cross-examination?
no, not cross, because no, I thought cross is when it's with trial, but you know
Right.
how like they sit down, I don't know what to call it, and I'm just trying not to call my
I think it's
Oh,
deposed.
I think someone in the chat may have said what you're talking about. Are you talking about a deposition where they take
that's what I'm
testimony
talking
before?
about. Yes,
Yeah,
yeah, I couldn't
that's a
remember for
deposition.
okay, will we be able to see that? Can we like request those papers and read what was said, because they documented, recorded, and all that stuff.
Yeah. So if there were depositions taken, which I think that might have happened in this case, right? The record should have the depositions and everything therein contained in it. Meaning, if you go and get the court records, you should also get the depositions with everything noted therein. I will say though, you got to be mindful that there's a minor in this case. So things happen differently, right? That's in general. But you may find that the deposition of the minor is sealed and you're not able to get that, right? There may be some things that are different in this case.
Okay. Because I figured they probably just, what they call when they DAC or cover, the name, the privacy, certain things. I was wondering, but I was just curious if we could get those paperwork. Thank
Yeah,
you for answering that question.
You're welcome. In general, you can. And yes, sometimes they redact, which is like to, take the child's full name out, take out certain details. Sometimes they do that, but sometimes they just say, this is a minor, you cannot see it at all. And again, that is the discretion of the judge. Some judges will redact like crazy and let you have it with, a bunch of redactions. Other judges will say, no, I've sealed it all together and you cannot get access to that.
Okay, cool. Thanks.
You're welcome. Okay. So Kim, Neo in Texas, Bama, you're welcome to stay if you like. I want to answer this question. TSW, what is the difference between probation and reporting probation? Okay, so in general, probation is probation, right? And as we've discussed, I already went through my whole diatribe about what probation is and how the person has an officer they have to report to and all the conditions, right? Reporting probation is a term that people sometimes use when they're referring to probation that is specifically in lieu of incarceration. So specifically in cases where instead of incarceration, the defendant is given probation, sometimes they will refer to that as reporting probation, right? But in general, probation is probation. Persons who have been charged with crimes that involve minors, persons who have been charged with crimes that involve SO and SA, they usually have even more strict probation terms, probation conditions, and length of probation than your usual probation. Okay. All righty. So someone wants me to speak on the involuntary civil commitment aspect of the plea. But then you said that Attorney Shabazz spoke on it. So sounds like it's been spoken on. All right.
Can I jump in real quick?
Yes, go ahead.
And this has nothing to do with the law in terms, but this has more to do with having integrity, a moral compass, whatever you want to call it. I'm just so disappointed that these so-called people that have been presented to us as quote unquote leaders seem to just be, there doesn't seem to be any integrity, any morality, any character, any moral compass. And it's just, to me, it's just sad. That's all I have.
Well, what can we say? There are over 100 of you here and 65. Let me refresh it and make sure I'm not tripping. Because how hard is it, y'all? Oh, I'm tripping. It's 116. Love you guys. You can still do a little bit better though. Okay, question. Claymore Jones. This pertains to the amended charges. Were the charges only amended because Polight agreed to plead guilty to them? And if he refused to plead guilty to them, the charges would not have been amended. Okay. So Claymore, you may be a little late. Okay, so you may want to run it back. But we addressed amended informations and why they are amended. Again, just to note, the charges that Polight eventually pled guilty to were not even on the original charging document, right? So he can't plead guilty to charges that don't exist. So they had to amend in some way, right? And thus resulted the amended information. All right. Oh, let me put the link back in. I forgot that it was quite some time ago that I put the link in the chat and then I forgot to put it in again. All right. I got mods in here, don't I? Somebody pinned that link. Come on, mods. You should be modding. Don't I have? Let me go to my live chat. Yeah, I got some mods in here. Let's get to modding. Come on, y'all. All right. Gilly said EE finna get us with her bag. Y'all know sometimes I get in my bag. Oh, Yua Akata has a question. Hey, Yua, how are you? Or you? Not Yua, you. Hey, Yua Akata. can I go over how they can make him participate in the MDSO? Okay, so once more, a plea agreement is an agreement. It is a compromise, and it results in all parties agreeing to the terms and conditions. So they don't have to try to get him to participate in anything. He agreed to participate in that program in exchange for him getting the 7 years incarceration and the 10 years probation. Because as we discussed, he was facing a lot more than 7 years, right? So this is a compromise. Again, he's not being labeled as an SO, but he has all the SO terms and conditions. And I imagine that that is the compromise. I imagine that it's possible that he had a big problem with being labeled an SO and that the government / prosecution said, okay, we'll skip the label, but you still have to do everything we need you to do. All righty. I hope that answers that question. Eliezer has a question. He says, concerning all the alleged scams he's been doing, he has effectively dodged responsibility by never having a residence. Interesting. Now that he has a location to be served, can they pursue him? You know, that is quite interesting. The idea of, can you serve someone who is incarcerated? I have to tell you, that's an interesting concept. It's an interesting concept that I've actually never even considered. I've never had the instance to consider that, right? Because in my practice, the civil cases that I've been involved in have been corporate, you know, so it's interesting to even consider that. But I will say this. I have heard of persons who are getting divorced serve a divorce on an incarcerated spouse. So I would say, yeah, you can serve someone that's incarcerated and they do know where he is now. So it's possible. We'll say that. All right. Neo X philosophy. Oh, is this Neo that's on? Is this the Neo that's on the panel? No, that's a different Neo.
No, that's me.
Oh,
Wait,
okay. But your
hold
picture
on.
looks.
No, yeah, that's me. Yeah,
So you make content as well.
yeah, I'm a content creator.
Okay,
I'm getting things a little shaking up in the conscious community. I was one of the first ones to kind of speak out. And I warned Sarnetta about, you know, saying certain things on his panel and re-victimizing the victim. Kind of got a little pushback because of that, but you know, it is what it is. I always felt like we should have did a better job protecting the information that was being released. So
Everyone check out Neo X. From what I'm hearing, she does conscious community commentary, and it sounds like she's pretty dope. All right, so check her out.
Oh well, not conscious. I do all types of stuff. I'm just saying
all
that.
different types of commentary.
Yeah, it's a lot. It's a philosophy channel. It's open to all types of communications and, you know, stuff.
Okay, then. All righty. So, yep, everyone, another content creator that you should visit. Let's see. Are there any other questions that I'm missing? Someone said R. Kelly got served. Yeah. So I've heard of people serving divorces, which in essence is a lawsuit of his own type. So yeah, I imagine that he could be served. I think someone else has joined. Oh, Naps is in the building. All right. So let's invite, and Trip is back. So, or Trip, are you back or no? I don't know. All right. So the artist formerly known as Nappy Yankee is in the building. What's on your mind, Naps?
Yeah, can you hear me okay?
Yeah, we can hear you.
Can you hear me?
Yeah, we can hear you. Can you hear us?
Yeah, I can hear you. I can hear you. Yeah, I just have one simple question because I understand where you're coming from a legal standpoint. And the win that Polight seems to want to hang on is that he's not labeled as an SO, right? So that's kind of the win. That's kind of what he and a lot of his goofy followers are leaning on. And it's laughable with these dudes in the conscious community or the quote unquote pro black, where they will tell you all day, don't follow the white man's law, and well, why are you listening to him? It's his side, the white man's science, blah 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 blah. until they benefit from it. Then they swear by it. You notice that. Anytime whenever they benefit from it, then they'll swear by it, and they'll say, "Man, well, look at the law." They turn into Johnny Cochran's all of a sudden, and it's like they sit down, and they study the law, and they know everything about it. But here's my question though. At the end of the day, he is going to jail for 7. He's in jail now. He's going to be there for 7 years, right? And this may be a dumb question, but I'll ask it anyway. The fact that there was DNA found, is that one of the reasons why he is doing jail time?
So it's hard for us to say because there was no trial, right? So a trial, we could sit here and discuss the evidence that was presented, but that is not what happened here, right? Here, what has happened is a plea agreement. So the conversation about what evidence exists or doesn't exist, as the public, as the general public, there's always going to be some level of speculation, right? We get court records, but the records don't tell you the extent of what evidence was available. So without a trial, there's always some level of speculation as to exactly what occurred with the DNA and what was said on the record about the DNA and where was the DNA. And yes, you can go and pull records and try to decipher from those where things were found. But at the end of the day, we did not have a trial. We just have an adjudication that is a plea agreement, and that is what we have to kind of hang our hat on.
Well, I mean, everything in that plea agreement, it has a bunch. He's not labeled an SO, but there's a bunch of SO conditions. It's kind of interesting. Like there was a case of out in Ohio recently where a girl, she got killed for I guess robbing a store. Had she lived, they wouldn't have charged her with extortion. If she went to prison, they'd charge her with robbery. With robbing a store. So it's semantics. I mean, if this is what they want to hang their hat on, that's their business. I mean, I know what I'll call it, and it's just kind of laughable. And the people from the conscious community, I can't even call it like con with I mean, just emphasis on con, by the way. But these guys, man, I mean, they want to hang their hat on this. That's cool. And the response from some of the so-called leaders, not just Sandetta, but also the Umars and Tariq, who said something just outrageous today. But yeah, man, if they want to hang their hat on this, they could. But I know what I and others are going to call it for what it is. So that's basically it.
Right. I mean, as we've said, it is what it is. Is he labeled an SO? Not necessarily, but we heard the terms and conditions. So we know what occurred.
Yeah.
All righty. You got anything else for us, Naps?
Nah, that's it for now. I'll just go back into the chat. Thanks for having me up.
Oh,
if I could,
go ahead.
Yeah, I just wanted to kind of piggyback off of that a little bit to ask if they do have video evidence from the hotel, would we be able to request that as well?
So here's the thing about requesting that video evidence. So you would have to be the type of body or authority or agency that could request that, right? So you're not a state attorney's office. You are not a district attorney's office. So you could not request that as just a general member of the public. Now, if the prosecuting attorney or the office that prosecuted Michael Noack has videotape and you want to see that, you perhaps could do a Freedom of Information Act request, right? But then they always have the possibility of telling you a minor is involved. And so we're protecting the minor by not releasing this. There's always heightened protection there when you have a minor involved.
Okay.
Okay, so I'm looking in the chat. I don't think I'm really seeing any other questions. And we're at almost 2 hours. Okay, so does anyone up on stage have any further questions? Bama,
one more question.
Trip? Go ahead, Trip.
Okay, so say the scam victims did get together, would they be better off filing a civil suit or going for charges?
You know, that depends on what they're looking for. So if they just want the banner of justice to, reign, then they could try to file police reports and see where they would get in a criminal case. But if they're really seeking compensation for the money that they were scammed out of, then civil court would be the best place to go. However, you're not likely to get much in terms of financial compensation from
Because
someone
he
who's
ain't got nothing. So let me
So,
rephrase the question. What would be the best thing to try to charge them with?
oh, to try to charge him with that depends on the state because some states are not as advanced as we would like. And a lot of his
Mhm.
alleged scams involve technology, right? Cash App and PayPal and things like that. And there are some states that their laws are still very archaic in terms of sending someone money electronically and what is required for you to actually be able to place any imposition on that money, right? And then a lot of these online personalities, they take donations as well, right? So then the question
Mhm.
becomes, well, was this a donation or was this a payment for a service? Can you prove that it was a payment for a service and not a donation? And then it gets really murky. And so it depends from state to state as to whether or not he could actually be held accountable.
Would they be best served filing in Florida?
I mean, what would be the if they're a resident of Florida, but if they're just trying to file in Florida because he's incarcerated there, that could be a problem.
Okay, so they need to file in their states of residence.
I would say that a plaintiff would be better off in their state of residence. Also for the convenience, right? Do you want to go to Florida every time? Yes, some courtrooms
True.
have Zoom capability, but not all. And so that would cost them even more to try to, actually go through with a lawsuit that's based in Florida.
Okay, if the person that was scammed is deceased and one of his family members want to pursue a case that was already in process when he passed, how would they go about that?
Is the defendant deceased or is the plaintiff deceased?
The plaintiff would be the person that got scammed, right? I'm just making sure.
Yeah, the plaintiff would be the person that got scammed.
The plaintiff. Mm-hmm.
Interesting. So the estate can continue, but that has to be a motion to the court in which it is explained to the court, listen, the plaintiff is now deceased. His estate would like to continue with seeking compensation. And then that judge would have discretion of allowing the case to continue already in that same docket, if you will, under that same case number. Or the judge may say, hey, we're going to close this and you need to refile as the estate with the plaintiff as the estate. So it will depend on the discretion of the judge in that case. And also the local rules as well, because the local rules there may speak to whether or not the estate can continue or whether or not the estate has to file their own separate case.
Okay. Thank you.
You're welcome. Any other questions of anyone on stage?
Do you see the comment from Off the Grid? Do you see that comment?
Let me see.
That was a little disrespectful. Okay.
Huh?
Yeah.
I think that person might be under the influence of something because
it's a troll.
I mean, what does this conversation have anything to do with that statement? Okay, so they've been banned forever. Okay, so they'll have to create a new name to troll again. All right. Oh, and Kuang just said something I want to highlight before we head on out of here. And that is probably one of the main reasons for him, aka quote unquote Brother Polight, not having a trial. Evidence. Everything that we discuss now has to be based on a plea agreement. If there was a trial, a lot of these things we wonder about DNA and this and that, all of that would have come out in trial. And believe you me, quote unquote, Brother Polight and his attorney, they thought about that when they were thinking about whether or not to take plea. All right, so this has been another installment of Empowered Esquire podcast. I want to thank all of you for joining me. You are amazing. You are awesome. Listen, if nobody has told you today, this week, this month, whatever, I love you. You bring something to this world, to my life, to my channel that no one else does. And I think you're pretty awesome. All right. So I'll see you next time. I know I still owe you some, installments that we talked about. Cut me some slack. Okay. But I'll see you around. Email me, comment. If you're replay gang, please leave your comment below with any questions you have, and I will be in the comments answering your questions. All right. Okay. Bye-bye.